Okay, everybody, we're going to get started with our first panel today. Doing pretty good, only 4 minutes late on day 2 for a start. I think that's really good. We're practically on time. Practically on time. All right, so and this is a CLE hour that we have. It's best practices for building a worldwide patent portfolio. And there's materials on the panel page that are being submitted for purposes of CLE. There are articles that were written by either me or John has written several of the articles as well. So let me at least briefly introduce the panelists. And again, like I was doing yesterday, I'd appreciate it if you could also introduce yourself a little bit more, particularly with your scientific background, perhaps as is relevant to maybe answering some of the questions that may come up. But we have, from your left to right, we have John White, who is a partner at Harness IP, and he is also, by now, taught probably 50,000 patent attorneys. He doesn't like that number, but 40. He says 40. He's been saying 40,000 for the last 10 years, but he's been teaching patent bar review, as most of you know, since about 1994, 1993, and he's helped. We hear he's the voice of God a lot. You know, the voice in your mind that you can't get rid of, but for good purposes. Always a pleasure to have John here. Rob Rodriguez, who is a partner at Licks Attorneys, who came all the way from Brazil to be here. We really appreciate you making the trip. Thank you very much, Rob. We also have Gary LaBelle, who is senior patent attorney at Reckitt, and he is also former chief patent counsel at Nestle, and hopefully we'll get some stories about that, about Nestle here today. Which is not like gossip or anything, but there are some things that are relevant to the conversation about Nestle's worldwide strategy. And then last but certainly not least is Cynthia Deal Mitchell, and she's Associate General Counsel and the head of Global IP for ZimV. And which is a company that does prosthetics, among other things, and she was just giving me the lowdown on what I have in store for next week when I have my hip replaced. So. Hopefully I'll have a ZimV joint. All right, so what I like to do is just start by asking a wide open question, and what I'll actually do is I'm going to start with Cynthia. I'm going to go in reverse order, and the reason I'm going to pick on you first is because we're doing this panel really because of you. Because I remember inviting you to talk, and I asked you what it was that you wanted to discuss, and you said you'd be interested, and maybe you didn't say you wanted to discuss this, but like others, you said, well, I'd be interested in hearing about worldwide patent strategies. And so thank you for the idea for the panel, and we'll let you go first. So what is it that you would like the audience to have at the top of their mind as we begin the conversation today?
I think as companies do acquisitions and divestitures, to just be aware when you're doing the due diligence of sometimes you acquire a company that is outside the United States, and there are aspects of IP that are very, very specific to the United States. For example, we require the actual inventorship. Other countries do not. And you may acquire a company based in another country, and certain countries require that the inventors be adequately remunerated for their IP. And so a lot of people end up on the IP. And a lot of times, it's not the inventor. And you may have acquired the company for their IP, and you want to move the product into the United States. Now you've got a problem on your hands. And a lot of times after you acquire a company, you start to lay people off. Some people might leave during or because of the acquisition. Likewise, when you're also looking to divest parts of your company, you may not have done IP on a worldwide basis of filing for each business unit. They may have decided, well, our company mostly works in this country or whatever, and you file IP based on that, and then you spin off some of your business units, and their IP is in the wrong countries. So just be more aware of things like that as you're looking to acquire and divest business units.
Great, thank you. And that's exactly what the focus of this panel was intended to be, was that type of a conversation. And John, I know, I'll go over to you. This is something that you and I actually talk about quite a lot, which is why I asked you to be on the panel when Cynthia told me what she was interested in discussing. Because we talk about this all the time. And you as a practitioner, patent prosecutor, but also once upon a time in your career you did litigation. What happens in the situation where you have something like that? We always talk about when that comes up in the deposition, 2 people leave the room.
That's right.
So can you tell that story a little bit?
Yeah, the story we've always told in patent bar review is that the patent office doesn't care about ownership; they care about inventorship. The court cares about ownership. Who can sue who, but the PTO cares about inventorship, and it's your obligation to get it right. And so the story is, you're visiting a client, you're drinking, obviously, in the evening, because that's what you do. And at some point, you congratulate them on this amazing inventor who's just a Renaissance person. They're on every oath that gets submitted to the United States. Chemical, electrical, mechanical, just doesn't matter. They're amazing, and you congratulate them, and they say, yeah, that's the company president. This is a feel-good thing for them. It builds their self-esteem. They're actually not an inventor. And this happens, and so you have 2 things you can do. You can drink until you forget, or when you return, you have to fix this. It doesn't have to be the first thing you do, but you're obliged to fix it. And so I tell people outside the United States, inventorship is political, not factual. Whereas here in this country, it's factual. Who contributes to conception? Not who was in the room. It's not who led the team. It's not who contributes to conception of what's claimed. And this is hard to communicate because they were like, well, but they did so much. Yeah, but that was reduction to practice. In the United States, we care about who contributes to the complete idea. And so this is just one factor, in trying to secure patents and getting them from all over. But with respect to what I find interesting about the world and patent portfolios is most people think the world is static in some respect and that the U.S. will remain on top forever. And that's not true. Now, we can all recite the top 5 economies from memory right now. China and the U.S. are at the top, and depending on what metric you use, either one is in first place. India is number 3, followed by Japan and Germany. Okay, we can all more or less think, back of our mind, that's true. Okay, so the IMF says by 2030, Japan and Germany will be number 9 and 10 respectively. Okay, who's going to be in the top 8? Okay, China, number 1, right? India, number 2. U.S., number 3. Who's number 4? Indonesia. How many of you are pondering Indonesia as the next place you're going to get patents? And the reason I ask that is the decisions we make today, where we file, what we file, and our strategy going forward is going to be something that reflects what happens in 10 years. The sweet spot for enforcement, licensing, acquisition is 10 years out. How many of you had Indonesia on your short list for the future? I see a lot of hands going up. Next, we have Turkey. Turkey, anyone? The edge of Europe? Yeah, not so much. All right, Brazil, well represented. Got Rob here. Egypt, number 7. Anybody? Egypt. I see one hand, courageous. Yeah, okay. Then Russia, and then finally Japan and Germany. But Indonesia is going to be twice the size of Germany now in 10 years. Why? Because of the middle class. What do they want? They want telephones, they want communication, they want mobility, they want all the things any middle class wants. And so that's where we're headed, folks. The United States is going to grow as well, but it's going to be a smaller proportion of something that's much larger, the rest of the world. Mm-hmm. So getting worldwide patents and having a portfolio and a plan is vital to the future of your company. And so that's what I'm preaching, is prepare. Make decisions now and execute. But I'm preaching.
Yeah, that's fine. No, that's the point. And Rob, Brazil is really growing quite a lot. I mean, everybody's interested in Brazil. I mean, it has a huge market, it has huge potential, it has vast untapped potential, and oh, by the way, you can actually get an injunction in Brazil. So tell us about what's going on from your perspective. And I know you do work all over the world, but like in South America, Brazil particularly, what are your clients talking to you about?
Yeah, sure. Thank you. So a pleasure to be here, and it's quite interesting of giving this international perspective. And on a Brazilian perspective, what we most see is a lot of our clients ask, but in the end of the day, what is a patent for, right? Because there's lack of actually knowledge of what's the IP system. Okay, we all understand that the IP systems hopefully will foster innovation, but what's the difference between, even in very like simple question, what's the difference between a patent, a trademark, and trade secrets? And we got that a lot. And here you don't realize, but you guys have like a fancy patent bar examination. You have professors doing that for life, and in Brazil don't have those stuff. Like when you talk patents, is like this is a foreigner, a gringo, and we see that those guys coming here, filing patents here, they want like our property, they want this. But it's shaping now, right? Like you have local clients, local companies learning more. They ask us, okay, the first questions we receive when we started to do some roadshows with Brazilian clients is like, okay, but I do have a trademark in the US. Why should I file those 4 patents, right? So, and it was like, okay, and then we explain the difference, and now they are excited about filing an IPR in the US, right? And spending $300,000 on an IPR, and like, wow, this is the very expensive system, right? Like, and we think, yes, it's a big market as well. So I guess it's a shape of mentality that's important. We don't see local clients carrying or actually going for injunctions. This is a gringo stuff. So we, for our international clients, they like the enforcement system. Or the local clients are not there yet. As John said, is a 10-year investment. So we're in the beginning of this curve where those clients or those companies are filing patent applications and filing patent applications outside of Brazil. But yeah, we have an interplay where in the South American market in general, you have a well-developed system of patents for foreign companies, and the local companies are catching up. So they are filing more, they are understanding more markets like US, China, Europe. Maybe I should advise them Indonesia, so this is something I learned today. I never thought about suggesting that to some of my local clients, so this is something new. But yeah, so there's a catching up on the curve of for local clients. We work for electronics, pharma, biotech in general, chemistry, and what do I do? How do I have a portfolio, right? And those are quite interesting. This is a quite interesting panel for me also to learn and improve my advice there for those clients. So yeah.
Yeah. So it seems like in Brazil, you're going about trying to educate the entire populace, particularly startups and small businesses, and it's an exciting time because they're tuning in to the possibilities, and I think that goes with what John was saying about how you need rights all over the world because people are starting to figure this out, and this is something I preach all the time. So I'll just preach a little bit here, and then I'll move on to you, Gary. Get your initial thoughts. Is the way that we used to do it in the U.S. is the way that the rest of the world is starting to do it and get excited about intellectual property and get excited about what it can mean and use it as a tool, as a business tool, and hopefully we get back to that in the U.S. But Gary, your thoughts. Feel free to take it anywhere you want, respond to anything that's been said, or bring up something new.
Yeah, one of my initial thoughts is that companies that I've seen both doing due diligence and companies I've been with, there's a rule from up above: budgets have to be cut, and then they cut countries. They don't cull the portfolio strategically. They just cut, and I had one instance at a previous company where the business unit was looking to move into a certain country. And that country ended up being totally cut out, and when they tried to move into the country, a couple years later, they had competition that wasn't there when they started the plans. So they saved a few $1,000s, but it cost them millions. And I've seen this when I was doing due diligences a number of times. The places that they actually patented in aren't places that were very strategic. And small companies have a limited budget, and they think we're going to go after these big markets, and they go after the biggest markets, but it may not be a market that uses their product.
Yeah. Yeah, it's you have to be very selective, and that gets back to where we started. So, Cynthia, I'll let you have sort of the last word on this introductory part, since now, if you want to respond to anything that anybody has said, or if you want to kind of dive a little deeper, go right ahead, please.
So I guess bouncing off some of the things that have been said here, I found that like startup companies, they really need to look at where do you need IP to get the venture capital money in, where do you project your first, markets to be, and it depends. Like you have a limited budget, right? And they're doing things on a shoestring, so you have to very strategically pick where to file your stuff to attract the venture capitalists. Medium-sized and large-sized companies, they're always cutting the budget. It's rare that they're like giving you a blank check, right? So they're always cutting the budget. And for me, my client is like right now I'm the sole IP counsel for a company, but typically I've been in-house and I represent certain business units. I see my client as the business units, and sometimes I'll get an edict down from general legal or whatever. Okay, we're cutting the budget. Everybody has to cut out 25%, cut out your most expensive countries outside the US. Well, of course, that's Germany or whatever. Like some of them are pretty expensive, but they've got a really good fast track to litigation if you need enforcement. And if you can enforce there, you could block most of the EU or something. And so I look at my business unit. I go to my business unit. I say, okay, if I give you $100, tell me what over the next 5 to 10 years are the most important countries to you. Where are you selling? Where are you manufacturing? Where's your competition selling? Where are they manufacturing? Where do you see you moving into? And then I'm going to pick my countries for each business unit based on that. I'm not going to do a corporate-wide look at, this is for the bulk of our revenue, this is where we care about, because it needs to be by business unit, because you could sell off those business units. You also might do a cross-license agreement. And let me tell you, if you do a cross-license agreement of your patent portfolio with a company based in Japan and you have 0 Japanese patents, because guess what? Japanese is not a litigious society. That looks bad in negotiations, right? And so you have to think about this. Where is the competition? Where might you do a cross-license agreement? And really pick strategically. And when you have to retract your patent portfolio for the budgets, try to do like a checkerboard pattern withdrawal. Don't just cross out an entire country. Just go, okay, I'm just going to randomly pick some to cross out of different countries, but leave a checkerboard out there, because you never know when you're going to need that later.
Yeah. And John, I want to bring you in because maybe you can tell the story of our friend from who was at we won't name the company, but a major car manufacturer in Sweden. And Ray Millian was chief IP counsel for Volvo for a number of years, and he's a good friend of ours. And he had an interesting strategy going along with what Cynthia was saying. Can you explain what his strategy was with respect to not where he was applying, where he did not apply?
Right, and this is curious. So we talk about where are you likely to make use of your patents. Well, how many auto manufacturers are there in Sweden? Go ahead, use all your fingers.
See, that's why you laugh when I say, I won't name the company, but they're a major auto manufacturer in Sweden. There is one.
So who do you need to sue in Sweden for auto manufacturing purposes? Yourself? No. So you don't apply in your home country to get a patent because it doesn't make any sense to. So you apply where you might make some use of these patents, which is a stunning bit of insight because we think, well, number one, we're going to file in the United States. Okay, well, time for more of a story. So tubular food. Does anybody know what tubular food is? It's hot dogs, right? It's also the least expensive form of protein you can incorporate into your diet, slice of sausage. So there's a company in Waynesboro, Virginia, represented them for like 30 years, and they do nothing but handle hot dogs from when they're cooked to when they're packaged. They're in between, okay? Their sales are 90% outside the United States, in places where the middle class is developing who want to incorporate protein into their diet. They're tired of the rice. They're tired of the beans. They want some protein. And so you can have a company at the bottom of the Shenandoah Valley whose horizon is over the horizon. And you have to think about this strategically. It's not, well, we would never get a patent there. Well, you should, because that's where your sales and repair is going to be, And if you want to stay in that market, you better be a part of it. Get a seat at the table 10 years out. And that's what you have to find out from your business folks. Where is it that they're going to take the company? What do they want to achieve? Help them achieve that. Don't come up with standard stock plans. It's different for everyone. But you got to be there. I was listening to a company talk about their parts are throughout these server farms. Okay, well, where are server farms going to be in 10 years? You think the U.S. is still going to be ground zero for the internet, specifically Loudoun County? It is now, but in 10 years it won't be. Gene and I always wonder about that. We live in Loudoun. We think, well, when the bombs fall, they're coming here first. But, maybe in 10 years they'll go somewhere else first.
Yeah, because all those buildings that you see coming from the airport,
Are all server
that
farms.
nondescript that you might say, oh, well, that's probably CIA or whatever. They're all server farms, all of them. And they line go from one end of Loudoun County clear to the other end of Loudoun
And the
County.
ones with the razor wire and the electrified fencing, those are Department of Defense server farms. Just so you know, when you sort of a color-coded guide, oh, that high security.
So why do you think that Loudoun County is that relevant to the conversation? Why that may
No,
not
it's
be
just that
the future? Where do you see the future?
Well, it's the United States is going to be a smaller slice of a larger pie. And so the things that enable our lives are going to enable other lives in other places. And so you have to ponder what's coming, not what's been.
See, and that's interesting, because the last panel from yesterday brought up the same type of stuff, and maybe even more so in our pre-conversation about predicting the future and the importance of predicting the future. Rob, it looks like you have something. Go ahead.
No, yeah, I think this is like an interesting thing that John mentioned. It's and we have an experience with a Brazilian client. It's the largest local silicone implant company. And if you ever had any curiosity and research about that, Brazil is like a touristic place for people to go there and have a silicone implant because it's so well developed there, so much better than any other place. And this company is basically the number one company. Until a couple of years ago, they had like 0 patents. Right? So okay, this is not an innovative business. And then we start to have meetings and say, oh, wait a minute, you do have possibility of filing some patents here. And we put together a strategy where we file some provisions in the U.S. And one of the meetings with the CEOs and the people who make the strategy, he saw the numbers and say, wait, if we are the number one in Brazil and we know how to make it, why don't we go to U.S. and, I don't know, make that in the U.S., dominate there, like it's big market. And I can be the top one company in the U.S. on that as well. Like I can compete with those. So it's quite interesting how filing more patents actually is driving a business decision, and now they are considering an IPO in the U.S., bringing all the knowledge, all the R&D here, and let's invest on that U.S. market, right? Instead of having people coming from the U.S. To Brazil to do that, I'm going to bring the technology there. And it's a change of mentality where when he saw the possibility, and okay, so I have patents there, I can consider an IPO, and I have the market there. you will spend there. And they ended up nowadays, I think, have 1 or 2 patents in Brazil and 7 in the US. So it's a Brazilian company, right? And so I guess this is interesting how also looking into IP can change, it can improve your business decisions moving forward as well.
So this is interesting. Gary, I want to bring you into this conversation because it seems like what Rob is talking about and is that there's a lot of excitement in startup companies and smaller companies and growing companies. And we see this in the U.S. There's a company here in Loudoun County that John and I have done some consulting with, and they're just a great company. And they're in the SEP area. They're a small company. They're growing. But their CEO has 200 patents. And they built the technology of the company based on his patents. And he hires his PhDs, and they write the first draft of the application. They are very patent-centric. Not a lot of big companies are, and it seems like there's this passing in the night. You either get it or you don't get it. And increasingly, the large companies are the ones that Cynthia was talking about don't get it. Can you give your perspective on that? Because I know you've worked a lot for larger companies.
Yeah, I've worked for probably large multi-billion-dollar companies for over 20 years. And they don't look to patent everything. And sometimes, and even when I was doing due diligences, you ask about a certain product and they said, yeah, we couldn't get a patent on it. And the story I always give was, we had a product we were developing, and when I got the disclosure, I started looking at the prior art, and we couldn't patent our product. But I could patent everywhere around it. So for 8 years, there was never a similar product on the shelf because the generics never figured out they could make our exact product. They just couldn't make anything similar. And I think people stop at here's the product, how do we protect this, when sometimes it's the competitive insulation that could be even more important. And big companies, their budgets, they want to keep them tight. They're not always looking there. They're not hungry enough.
So let me also ask you, because our friend Ray Millian also, these are things that we've heard him say. He used to teach the patent bar review course with us periodically. So these are things he said publicly to students. And one of the ones was that he always wants a picture claim in all of his patents. Because if you're going to protect something, I want to protect what we actually have in our cars and what we're making money on. Mm-hmm. And then you go from there, widen it out as much as we can. But he was not afraid of picture claims. And I think particularly in an industry where you have a bunch of potential copycats, too often people are afraid of the one column claim. And what are your thoughts on that?
The one column claim, if you can destroy the main claim, usually the rest are going to end up falling. You've got to protect it from different aspects, and you've got to look at variants, and sometimes the most likely variants deserve their own protection for that insulation. And it's just protecting it also from different aspects too. I'm very infamous for writing provisionals with a few hundred claims and having multiple dependencies, and you go into the PCT, but I will tell you that strategy saved me more times than I really care to realize. When you're prosecuting in a foreign country and they say, you really never considered that combination, you go, yeah, it was claim 621 in the provisional, and they look at it and go, oh, okay.
Yeah, that's interesting. And it comes out to best practices. If you do best practices, and you're saying, so you probably have all seen the surfboard that we have, or wakeboard we have in the other room, and that is not only a very attractive kind of prop for our office decoration. That was a client that I helped with a provisional application many years ago. And like so many small companies, they couldn't exactly tell me why the wakeboard was unique. But they had a video of guys bigger than me getting up on this wakeboard. Now, if you're a big guy and you ever try to get up on a wakeboard, what you do is you just get dragged around the lake until your arms are too tired to try and get up. So they had these like college linemen that they had recruited that were 325 pounds, just popping up on this wakeboard. They had elderly grandmothers just popping up on this wakeboard. So I knew that there's something going on there, right? And they're like small company. I asked them, I was like, why don't we hire some physics professor to figure out what the physics is here? And they didn't have the money to do that. And I was helping them the best that I could. And then what wound up happening was they kept saying, but what's unique is the method of riding the wakeboard. And I'm like, okay, all right, well, if we're going to do that, then what we have to do is we need to storyboard this thing. So then John, I'm going to bring John into this conversation because John took over this case, and we finally figured out what was unique about this wakeboard. And it wasn't exactly the method of riding it, but it was the storyboarding of the method of riding it that allowed for the description of the physical aspects that made this so easy to ride. Can you tell that story?
Yeah, this was an interesting story because it takes away the need for upper body strength to ride a wakeboard. And if you've ever done water skiing or anything like that, the most difficult time is staying balanced and getting out of the water. Well, they just put a hook on the wakeboard. So that drug you up out of the water, and then once you're planing, it's like standing on the porch. And then they had a double-handled hook, so you didn't have to grab the hook and pinch your fingers. You grabbed the one above and stood up, and it was so simple. Literally, anybody could do it.
And then when you did the physics, when you actually did the physics, anybody could do it because if you mapped the center of gravity of the person as they're riding the wakeboard, it's just all balanced. The whole thing is designed so that you're constantly balancing.
The point of the story is put it all in. Put it all in. Because you never know.
Because you never know,
So,
and that's why you brought that
I
up.
love this idea of claims, because you get to the EPO and they go, well, I don't know. You didn't have a claim back there. Wait a minute, I got 400. What a great idea. Thanks, Gary.
Yeah. And when you said that, Gary, I mean, I was like, man after my own heart, because
Yeah.
I like the idea
Good idea.
of lots of multiple dependent claims and provisionals, because you don't have to pay for them, right? And then it's like, and you maybe don't even necessarily know all the combinations you've created. And if you have enough claims, then my God, I mean, it works. Cynthia, what are your thoughts about this? I know, like your company does prosthetics and some other stuff. Do you have to have a patent strategy that will address copycats or what type of patent strategy works for a medical device company? Is it different in any way? Is it nuanced in a certain way? I mean, do you get design patents at all?
We do. We do get design patents sometimes.
And then I know one of the other things we want to talk about is knowing the country you're going into and knowing it from an enforcement angle, and not only an enforcement angle, but like I yesterday used the example of the Port of Rotterdam. Not everything comes into Europe through the Port of Rotterdam, but if you have a product that does, it makes sense, right? Because then you have a lever to keep it out, the same way that we can use the ITC to keep it out, and it gives the people who have counterfeits an opportunity to work with customs, and so it can be a very interesting piece in the right strategy portfolio. So I guess what I'm asking, generally speaking, is what is a good? What do you think is a good strategy portfolio for a medical device company?
So for medical devices, it's actually a lot more important that you do a really good FTO, freedom to operate, because if you have to do a design round to avoid somebody's patent later, you probably also have to now refile for your FDA clearance, which is a problem because you can't sell product until you have an FDA clearance. So it's really, really, really important that you do a really good FTO because you don't want to have to do a design around once you have FDA clearance. So, being early in the game, working with your R&D folks and trying to find that sweet spot of, is the design far enough along that I can do an FTO, but still I can make you weave and jog a bit to get around any landmines I happen to find. With respect to, patent claims, in my mind, the most important patent claim is the one that your competition is infringing, and you don't always know that up front. So, and a lot of law firms, I find, they draft claims based on the most recent Supreme Court ruling or whatever, and I'm like, the one I care about is the one that happens 10 years from now, right? And so I don't care. I want you to have means plus function. I want you to have this. I want you to have every kind of claim there is, because I don't know what the ruling is 10 years from now, right? So put in every style of claim you can think of, and I don't care what they ruled last year. Put it all in there, and that kind of thing. So I have law firms that want to, what is your style? What do you, and they'll look at stuff that I drafted 20 years ago when I was drafting or whatever. I wanted to, make her happy. And I'm like, make me happy, do everything, right?
Right.
Think of everything, and don't worry about what the Supreme Court just ruled on.
So, okay, go ahead.
Do you file your FDA clearances in IDS?
No.
Do
Do you think we should?
Well,
You do that?
Some of the rulings that are coming out are saying anything you send to the government, to another government agency, if it contradicts something in your patent file, could
You gotta
be
give it.
could affect patentability.
Interesting.
And I'm starting to struggle with this. So I was curious, is there anybody else that?
Well, the safety is if you do it all the time, then you don't necessarily have to worry about whether it is contradicting something that you've said. Because it's easy to contradict things because you learn more as you go along. And it's like I said X, well, X turns out that it's not true. It's X prime.
Mm-hmm.
And then 10 years from now, when it gets litigated, somebody can say, you knew this, you hit it, it was intentional. It's like, no, it was an oversight maybe. It was, or I legitimately thought X prime was close enough to what we had said, But it is interesting. Anybody in the room have any experience with this or have made any decisions based on the need to file these? Okay, I know what panel we're going to do next.
You have a couple in the back. They're way in the back. Can't see their hands.
A couple hands? Okay.
The FTO, sometimes you have your outside firm doing your FTO search and they see hundreds, thousands of different references. But one of the reasons that I've seen that you have an outside vendor of FTO is so that you get a short list. So, if you had IP.com do your report, you would want them to send you maybe 20 references, the best 20. And then that's what you're going to put in the file wrapper to do on your IDS, so that's only 20. And then me, as your law firm, I'm not doing the search, so I'm not seeing hundreds, thousands of other related references. There's no risk that maybe I saw this really obscure reference, So you have the outside vendor or even your in-house search company. So I've seen major companies, they can have somebody who's trained to do that FTO and drill it down to like the top 10 or 15 references. And now it's a manageable IDS instead of hundreds and hundreds of things in an FTO search, and most of them are just garbage.
Yeah.
So having a person who's trusted to give you the top 10 or 15, very similar to a knockout and patentability search.
That's what I wanted done when I was an attorney from my search firms. I wanted them, and I stumbled on one that I worked with quite a lot, and what they did is they had an A list, very short, which was the ones that they thought were, really close. The B list, which had, a couple elements, and then a C list, which is, got quite long at times. I really didn't usually want, but occasionally there would be stuff on the B list that I did think was more relevant than the A list. But if you added the A and the B together, you were getting maybe sometimes anywhere from 10 to 30, depending on what the invention was. So what do you all think about that? I mean, since that's come up, I mean, do you want to know everything, or do you want to know the best? Because we know that the Patent Office prefers getting the best. They don't like getting dumped on.
Well, with respect to this particular situation that Gary's referring to, that was an instance, it wasn't necessarily unique, but they were trying to ride the coattails to get approval at the FDA, so they had to say it was like something else or like what they'd done before. Whereas at the Patent Office, you're saying it's unexpected, it's unlike anything that's ever been done before.
So it's one of those biosimilar.
It's precisely the opposite being argued with respect to each institution, but for different reasons,
Right.
And so if you find yourself in that situation, well, I would probably disclose it in the context of, well, at the FDA, it's a different standard, and for reasons that have to do with safety. Here, it's novelty and obviousness. It's a different inquiry. See.
Yeah. Yeah.
But that's what got them caught out, because that's one of the more recent inequitable conduct cases. And should you react to every case that is decided? Boy, I don't know. I don't think so.
Yeah, but led to an executive order.
Yeah. For an executive order that doesn't really mean much, but you're right. Yeah. But there it is.
Rob, it looks like you've wanted to.
No, yeah, just this is interesting interplay because since 2 years ago, the Brazilian FDA was a part of the patent prosecution for pharmaceuticals in Brazil, and during a lot of time was what should you do here? So the PTO and the Brazilian Patent Office and the FDA was fighting to see what should you comment on in terms of patentability, and there's so much struggle that in the end the government decided to remove the Anvisa, which is the Brazilian FDA, from patent prosecution. But there was a discussion about at least being able to say whether that patent was against public health. So if you trying to patent something that would be against the general conception of public health, for instance, at that time, cannabis invention, the FDA could say, no, you couldn't get this type of patent here. And now the Anvisa is not part of there, but there's some ongoing discussions here in the U.S. of making both the USPTO and the FDA closer. So I think this is might be a quite interesting topic in the coming future for here as well.
Yeah, I mean, I think that this is going to be an interesting topic. I don't think we've heard the last of this. But Gary, is there anything more to? Go ahead.
I have a question.
Sure.
But I know this might take things in a different direction. So.
That's fine.
I'm curious about sort of the intersection of your IP strategy and international sort of trade considerations. In Brazil in particular, among other countries, access and benefit sharing issues are starting to sort of creep up. We get a lot of questions around what are our obligations if we file on genetic resources that are based in Brazil, which may be indigenous to all of South America, but Brazil may make a claim to it, or some other country might. So that becomes sort of a trade issue, while also an IP issue and also a regulatory issue to some extent. India also has, their basmati rice was kind of a famous story around this, which led to the intersection of the Nagoya Protocol and cisgen in Brazil. So I'm curious as to, when you're laying out your international filing strategy, to what extent there's overlap that you're seeing and how you coordinate and manage those issues.
So that was a Brazil question. So we'll give it to our Brazil expert here.
No, so that's we.
To start, if anybody has anything else, we'll go to you too. But go ahead.
Yeah,
Rob.
we don't have an answer for that yet. So it's but because until now, what's quite interesting was like more seen as a bureaucracy. So most companies didn't have actually access to traditional knowledge in Brazil, but it's changing as more research is being done in the Amazon. So we see some companies already struggling about what to say or how, and we don't have a guidance by the government or the local patent office yet, but we see that might be an issue, and probably we will end up in litigation soon, because there is a lot of companies doing research in Amazon not reporting that to the patent office.
So what do you think is going to, I mean, based on Brazilian law and procedure, where do you think that's going to land if you had to predict?
We're probably going to have the environmental agency, the ministry handling the environmental law in general, stepping in. I don't see this being a sole patent issue. Probably you're going to have a guidance on general law that will have a change in patent law.
Yeah. It's really at the product level. So in Brazil, the latest proposal was that if you include a functional ingredient that's based on Brazilian natural resources or genetic resources, you might have to pay up to 1% of net sales on any products that include the ingredient, if it's functional. Now, functionality was never actually defined, which was a challenge, but it may be something that's more than an excipient in a formula. And then, no matter what you price your overall formula at, they would say, well, you have to pay 1% of net sales to the Brazilian government, which created a stir.
But the issue is who should enforce that? So there's no answer like, okay, but who is responsible? Okay, should you lose a patent if you don't do, or should you just pay tax? Also, in the end of the story, who will be trying to get your money out of this? We don't have that answer. There's no order in general, legislation on how do you pay actually that and say, make sure that, oh, I'm making my duty here. So it's a little bit of a challenge. The law needs to catch up still.
Yeah. Okay, so one of the questions that I think I asked you to think about, okay, so now we'll see whether you've actually done your homework assignment, is everybody's looking like, oh my God, what is he going to ask? It's actually, I'm just going to pull something straight from the description, is like countries to file in. And I think I asked you to like think outside the box, and are there any countries, like John started at the beginning, he listed of countries where there's growing economic activity, growing middle class, that sort of thing. Where is some place that you think people should be filing that maybe they're not filing? John, I'll start with you since you had the list. And was Malaysia on your list? I don't think it was.
Indonesia, no, Malaysia was not.
So because Malaysia came up yesterday, and as a possible manufacturing hub or growing, given the Chinese problems.
My answer is going to surprise you.
Okay.
Europe,
right.
Yeah. The unitary patent.
Oh, right.
It changes everything.
Yeah.
It has always been a pain to get a patent across Europe, because people think, well, I went to the European Patent Office and I got a European patent. Doesn't this mean I have a patent all across Europe? Well, no. You have to pay people a lot of money every year to keep it. You have to get it translated. You have to do all these hoops, and it gets more expensive every year. Isn't it great? Until 10 years out, you spend a fortune, achieve nothing. That's patenting in Europe, and it's like, wow, do I really want to do that? And so a lot of startups and small companies said, well, I'll file a PCT, but I'm not going to go through the EPO experience, because at the end of the rainbow, I don't have the gold to pay everybody for registration, validation, blah, 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 blah. Now, unitary patent. For the first 7.5 years, which is just matching it up with the US in maintenance fees, it's 1/3 the cost. And there's no translation requirement up front. There's one document you have to translate. That's it. It's free except for the cost of that translation. And the maintenance fees are nothing. And it's sort of a pan-European right across 17 countries. I know it doesn't cover everybody, but it covers France, Germany, and Italy. That sounds like Europe to me, and a few other countries. So here's the point. The unitary patent changes everything with respect to your European strategy, especially for small and startup companies, tech transfer, and stuff like that. Remember, the seat at the table you want is 10 years out. The UP gets you there. Don't worry about the Unified Patent Court and all that. That's for those who have patents and who, don't sleep at night and are scared of themselves. Think about the rights you can have 10 years out, okay? Everybody's opted out of the Unified Patent Court. Chickens. In any case, get a unitary patent okay, get one,
So-
especially small and startups.
So the reason, just like in case anybody is not aware, the reason that the companies are opting out of the court, at least initially, is because they are afraid, because if you lose the patent into court, then you didn't lose one patent, you lost 17 patents essentially in all the countries, which is a much bigger deal for those companies like pharmaceutical companies that have a small number of patents. You know, where like one patent is like on something like Humira, they make, you know, $14-15 billion a year. It's like, you were playing poker. Are you going all in Texas Hold'em, or you're not? And if you're a small company, a startup company, a licensing company, it probably makes a lot of sense to do the UPC and not to opt out of the court. You know, because there's a belief that the court is going to be quite favorable to patent owners, because unlike the PTAB, where it's the patent challengers that pay, it's going to be the patent owners that pay. You know, and you know, so the judges, if they want to have a job, they've got to create an environment where patent owners are going to do okay.
See, I think it's going to be patent friendly. The first revocation is Amgen, against an Amgen property. So what they ought to do is take out whoever challenged and shoot them, and then everybody will pile in. Hey, that's what the CAFC did.
Well, that's like,
under
you know,
Markey. Every patent was valid, infringed, and worth billions.
Right. They need to send a message quickly, and if they do, then it'll grow. So let me ask you, Cynthia, about your view of maybe the UPC. How does that fit in? Are you thinking about that, or should bio companies or biomedical companies like yours, device companies, be thinking about that, or are you more like a pharmaceutical company where you're a little hesitant because putting all the assets in?
Well, I think every company has to look at, you know, where they're at and where they're going and that kind of thing. I've been with a lot of really large companies that tend to have more and more be very short-sighted and run by bean counters, and they're looking to cut the budget. And so I want to be able to make small cuts of trimming the hedges, and so to be all in on something where, you know, you cut everything out if you have to cut it is problematic for me. So I'm actually moving away from EPO and some of the other stuff and going direct into countries, because when I have to start trimming the hedges, I just want to be able to do minor cuts and not lose an entire continent, you know. And so I guess everybody has to look at what they think is going to be the next 10 years for their company and where they're going. And are they growing really fast, or are they starting to be, you know, reportable to the street on a quarterly basis and cutting budgets all the time?
So let me ask you about the checkerboard, and I'd like Gary, you to comment on this as well. But Cynthia, your checkerboard strategy, can you explain a little bit? You mentioned it in the opening, I think, about having, you know, this, and now you're talking about having it in direct countries. But what is your idea of this checkerboard in order to like protect the entire continent without like patenting everywhere?
Well, it's going to be different for obviously every company, but you need to look at, you know, what are the markets you're into. And Europe is a really good example, but so is South America. What are the countries you're into? What are the ones that you get the most revenue in? What are the ones you're potentially manufacturing in on this continent? Where are your competitors at? Which countries are they selling in? Where's their headquarters? Where are their manufacturing sites? And then strategically plant your patents, you know, in a checkerboard fashion in those countries, and it's by business unit, or, you know, or if you get really granular, by product, you know, if you have the time for that, but by business unit at least, not company-wide. If you're with a conglomerate company, you know, that's problematic. You want to look at least the business level, put them there, and that way when it contracts, you know, you can start to trim the hedges a bit, but you still have coverage in that continent, you know, where you can block things. And you know, that's kind of the strategy I'm looking at. So when you start to talk about a patent that covers the entire country, like even the US, you know, that gets tough when you have to cut your budget and you get towards the end of a patent in the U.S. It's almost $8,000
Yeah.
to keep it alive. I got to go. Okay, what are the odds that in the next number of years, the next 5 years, I'm going to have to, put this patent on the table, because I can cut $8,000 out of my budget, and then I can file another one that's futuristic. So, when you're starting to have to trade pockets and pay Peter, steal from Paul to pay Peter and vice versa, you have to start to look at stuff like that.
Yeah, Carrie, I'd like you to comment on that as well, like your strategy, what you've done, what you've seen.
Well, I totally agree with what she said. And as you're trying to cut countries, because you have to cut your budget, you start to look at where is it being manufactured and how is it getting in, like the Netherlands.
Right.
Great port. I mean, whether you're manufacturing there, selling there, do it there, but sometimes it comes over land as well. What are the routes that's coming in at? And so you have to go from countries where you're going to go after infringers that's being sold to where is it being produced and how is it getting in. You can go from like 17 countries to 3. You're not going to have the same protection, but you cut your budget and you try to give the best protection you can with what you have.
Yeah, so let me ask you, and Cynthia, feel free to jump in on this as well. How important is the customs enforcement in the countries where you're trying to get protection? I mean, are you factoring in, okay, well, those are customs agents that they're not on the take and I can work with them? Because in some countries, let's just be honest, and not to be disrespectful or anything, but it is just, the customs is not easy to work with, and they may even be a little corrupt in some places. In other places, they're like here, very serious. They're police professionals, enforcement professionals. Does that factor into your patenting decision? And if the answer is no, that's fine.
It hasn't, but
Okay.
In the U.S., you can't stop a patent infringement from coming into the country.
No.
But I had an instance with a previous company that what we did was we put the company trademark embedded on every piece. When it came through, we were able to then stop it. So if you're in countries that won't stop a patented product from infringing, it's not can you do it, it's how can you stop that.
Yeah,
and you got to think out of the box.
And I don't think customs in the U.S. works with design patents, but I think there's been a push to try and get
Trademark.
They work with trademarks.
And I think putting watermarks that include your trademark and different things like that in your software, different things like that. You never know what the future holds. And a lot of times people are really lazy, copiers, and they don't look for those things, that kind of thing. So you just never know how you're going to be able to.
We've seen, like the third shift that the product brand didn't even know existed. It was completely off books. So it's like, well, how did they make this so good and for so cheap? It's because it's yours. It's your molds, it's your materials, it's your manufacturer. They're just off books on the third shift. So that when you say that they're lazy, I mean, sometimes they are not just lazy, they are criminal.
Yeah. And even, in movies and, recordings or whatever, like if there's a way to put a watermark in there with a trademark, I would look at every trick in the book, because you don't know how you could potentially need or be able to, you don't know what the next Supreme Court ruling in Brazil is going to be 10 years from now or whatever, where the market's going to be and who might be enforcing and how you might have to be creative in your enforcement. So anytime you can do stuff like that, I would just put layers upon layers of IP in there.
All right, so we are almost at the full hour for the CLE purposes, so I really appreciate this conversation. Was wonderful, but I want to give you all an opportunity to wrap up, and we'll just go around, starting with John. What is your final thought? If there's one thing, hopefully there's more that people will remember, but what's your one thing that you hope they remember?
For small and startup companies, get a unitary patent in Europe. It's cheap. It's almost free. I mean, you have to go through the EPO, but it's much, much more cost effective and within reach. And remember, you're looking 10 years out, and that's the easiest way to get 10 years out in Europe.
Right, and there is a real prospect. I mean, if you can get into West Texas in the U.S., you're pretty good, or Eastern District of Texas, you're pretty good. A lot of other courts in the U.S., you got no chance, and their feeling is you will have a chance as a patent owner in the unitary court.
Yeah, the Unified Patent
Unified
Court.
Patent Court.
Absolutely,
Yeah. So great, thanks, John. Rob, your one thing. What do you hope people remember?
Yeah, I think that 2-minute marketing is any company that has any chance thinking about Brazil, filing patents there because of the threat of injunction. So it's growing a lot, and we see a lot of operator companies that are being sued, and they have 0 patents there to launch a counteroffensive. So if you have any chance of being a defendant there, even if you don't plan to be a plaintiff, if you don't plan to enforce that, you need a defensive strategy, and filing patents is right now the most, might be the most important defensive strategy there. So you need to have tools there to negotiate and counterattack in case you are from any industry, not just telecom where we have the SCP wars, but also mechanics, agro, pharma, anything that I think this is the injunction threat there is real. Mm-hmm. Yeah.
Great. Thanks a lot, Rob. Really appreciate you being here. Gary, your final thought.
When you're handling your budget and budget cuts, be patent savvy, be smart with how you cut, and be a really good business partner to the business by not doing what you're told, but doing what's right and advocate for it. Because once you educate the bean counters, things tend to start going easier.
Great. Thanks a lot, Gary. And the last word goes to you, Cynthia.
I think IP, all parts of IP, are the poker chips to play commerce. And if you don't have poker chips around the world and can layer them, you're not going to be able to play the game, or you're going to, a lot of people are going to be able to hold you hostage, and you have to pay their ransom. So you need the poker chips. You need to be able to layer them and, have them across the checkerboard pattern, because you never know. Are you going to use them offensively, defensively, cross-license, sell off your business to venture capitalists or whatever, or a part of your business? And people are going to look at your patent portfolio to see where they want to take the business to determine whether or not there's value there.
Yeah. Okay, great. Well, I really appreciate this conversation, and we have safely gone over the hour by a couple minutes, so you have all successfully in every state we're applying for gotten CLE. All right, so let's take a 15-minute break, and then we'll come back.